executor, when one knows who one is. But as we've said, and it's worth saying it again, the role of general executor is one of the most difficult roles you'll ever experience. Why? Because one must be knowledgeable with the law. One must know the canons of law that are posted on one-heaven.org. One must be competent. One cannot be a general executor if one acts in the manner of vindictiveness and childishness. One acts as a guru. One allows the ego to run rampant. If one acts purely for selfish reasons and aggrandizement, if one seeks merely to make money or make money from others, if one seeks to enclose property for which they have no right, entitlement, all those things, all those actions are a demonstration that one is not worthy to be regarded as a general executor. And mark my words, the system, as it wakes up, will see those things and make clear to you that you are not demonstrating competence in the role. And if you are not demonstrating competence, you cannot be a general executor. It's a fail-safe. You want to be sovereign of your own affairs, act accordingly. You want to be free of their system, read, study, be competent. Don't be lazy, and please don't simply point and click and presume that you can do it in 5 easy steps. If you're facing problems, yes, you're in a point of crisis. But if we're facing a crisis today, it didn't come yesterday. If we're facing a crisis today, that might be the catalyst to cause us to get our affairs in order. But it doesn't mean we can cut corners as a general executor. Now, before I talk about birth certificate, because I did say I want to talk about birth certificate, but before I talk about it, I did say also I want to explain what public record is, because we use the word public record over and over in public notice, but what do we actually mean? And what does it mean in their system? Most importantly, what does it mean in their system? If you look at the statutes that created the concepts of roles and records beyond the parish, beyond the Vatican, if we go back to the ancient Roman times, then what we find is that the public record is the roles of the estate, the higher estate, as opposed to the roles or the registers of the lower corporation. So what do we mean by that? Well, in their system at the moment, the countries are effectively estates, and those estates have been declared bankrupt under the trickery of the Rothschilds and the other banking families, the parasitoids. So every 70 years, the estates have been turned over in a bankruptcy. But within those estates, they have trading entities. And those trading entities are the corporations. And the corporation has been running at a bankruptcy, and I've used different years before, but we're now pretty certain that the bankruptcy turnover is every 10 years. So every 10 years, they're liquidating the corporation within the 70-year cycle of bankruptcy of the estate. And how they do that is, before they liquidate, they do a stock take. And the stock take is the census. So the census is the way in which they do the stock take. And once they do the stock take, then they liquidate, and then they reform the new corporation. And those corporations are registered into Delaware through the SEC. So the public record is merely the record of the estate, which is still within the Roman system, still within their control, but that's what we mean by public record. That's what the public record is for them. Now, the fail-safe, if we don't nominate the public record being the estate record of the state rolls, is it will go onto the corporate record. So that's what we mean by public record. Now, before we get into birth certificate, I want to come back to form. I want to describe form for a moment and what form we're using. And I also want to talk about administrative law and fiduciary law. And then I will get to birth certificates and I will get to promissory notes. I'm doing this partly in reaction to the dialogue that's going on in the chat as we are talking tonight on TalkShoe, but I also think it's very valid. When we're speaking about the occupant of the Office of General Executor, there are a number of people who have spoken about the role of executor. And I have paid homage to them in the past, and I won't name them now. For some reason, they have not extended their knowledge to recognizing that there are many roles of executors within the Roman system, many roles, and we identify them, in fact, in positive law. And if you want to look at the different roles that there are in terms of executor, please go to one-heaven.org, then go to positive law, and then go down to, let me call it up so I can find it, to Article 270, executor. So go to one-heaven.org, go on to positive law, and then go on to Article 270 in terms of executor. And what you'll see under Canon 3048 is that there are at least 6 different types of executor that are recognized in their system. Executor generalis, or the general executor. Executor ab episcopo constitutus. That's a bit of a mouthful. Who are they? Well, that's the ecclesiastically appointed executor dative appointed to oversee probate, to administer an estate where they did not leave a will. There you go. We have executor testamarius, testamentary executor. We have executor nominatum. We have executor lucratus. Of course, we have executor de sanctor. So there's a range of different roles of executor. Now, there is a danger always, and I don't know why this has been a theme, but it has been a theme. There's a danger always that when people don't say things right, if people include their own presumptions, that it causes people to get into great difficulty. Now, there's 2 ways that they do that, where they put people in great difficulty. One is they claim their own forms as the remedy. They claim a private form will be recognized in a public manner in the Roman system. They claim a private form will be recognized in a public manner in the Roman system. And I'll tell you that that is the biggest proof of being incompetent, of being an idiot and a lunatic you could possibly do to the Roman system. To come up with a private document and try and get it recognized in the public manner. Now, when we did the ecclesiastical deed polls, I made it clear to everyone that prior to the work we have now done in Will and Testament, prior to the work we have now done in recognizing what the certificate of acknowledgement is and the records of the system are, prior to this forensic work, the ecclesiastical deed poll is a private document issued under private law, issued under the laws and statutes of one heaven, the covenant of one heaven. And in no way did we ever claim that that private document could be construed as a public document in their system. What we were doing was we were using the private ecclesiastical nature of it to appeal to the private side in their system. That is, taking it out of the public arena and meeting in chambers. Now, it was meant in many ways, and one of the ways that the ecclesiastical deed poll did is that it was a historic turning point at the end of the age of Mithra. It was ending the claim that blood, ending the claim that they have any legitimacy and superiority in their instruments, but it was never intending to pretend to be a prescribed form of statute. So when individuals take a prescribed form and play with it and break it outside of its prescribed form, it is no longer a public document in their system. It is in a private form. And if you try and lodge private forms into the public, then this is where so many people get into trouble. That's why if the name of a form is called a deed, it's a deed. If the name of the form is it's a certificate, it's a certificate. If there are prescribed words, those are the minimum words that must be present. Minimum. Not maximum, not only, but minimum words that must be on the document. So yes, there are examples and many examples of people over time who have got into serious trouble with knowledge. But the most common failure is that it's because people have promoted private form into claiming that it will be accepted in a public forum where it won't be. Now, I want to talk about administrative law, fiduciary law before we still get to birth certificate and promissory notes. The frustration that many have had when they go to court is they go in there and say, I will bind you to your oath and I appoint you a fiduciary, and the judge just laughs and continues on. And I know that this has been a frustration over years, if not decades, and I want to explain to you how this works. If you go and have a look, and this has come out of the forensic research that we're doing and completing UCADIA, if you go and have a look, you find that the penultimate law that underpins the corporate system in terms of their procedures is what they call administrative law. To the point that we see the word administrator as one who is appointed by an executor and don't think twice. We think it's normal. And when we talk about trusts and we talk about the obligations of being a trustee, we call that trust law. We've almost forgotten this word fiduciary. This word fiduciary is almost removed from our comprehension. And yet, before the role of the agent and agency was introduced in the 19th century, before they raised administrative law above fiduciary, fiduciary law, which states in its opening premise that fiduciary law, the trustee must serve the interests of others ahead of themselves, the interests of the beneficiaries ahead of their own interests. That was the law in which all the trusts administered. But when they introduced the concept for the corporate system of the agent through letters patent and through warrant, they created the concept that the executor could issue their powers to a particular man or woman or particular person for a prescribed period of time. So it was a forming of a temporary trust. And in that process, they would indemnify them. There was no obligation in that model at all. There is no obligation in that model to serve your interests ahead of theirs, to serve the interests of the beneficiary ahead of theirs. So it's a perfect marriage. It means an agent has the powers that they need from the executor, and they are indemnified by the executor to do their job. So when we encounter a judge that is fulfilling a role that is defined by deed or trust, and so that they are holding a fiduciary role, they are also appointed as an agent. And unless you remove the presumptions of agent first, you cannot get to their fiduciary obligations. Unless you remove the presumptions of agency first, you cannot get to them in terms of binding them to perform their fiduciary obligations. And this is how all officials are getting away with almost blue murder, because of the agency role. Well, how do you get rid of the agency role? We've mentioned this before, and I'll just quickly run through it before we get on to these other things. To remove the agency role, there are two presumptions of agency. One is, if you attend court, the presumption is you're accepting the judge as your agent. The judge is there, got their sign up, the judge is sitting there as a private contractor, open for business, and is there to arbitrate. The presumption is that you have appointed them as your agent.